Prior to the Virginia Declaration of Rights in 1776, it was legal for colonial courts to follow the example of England's Star Chamber and High Commission and submit prisoners to intense inquisitions. In order to force confessions and oaths, prisoners were regularly tortured and mutilated. After several states petitioned for prohibition of self-incrimination to be added to the Bill of Rights, James Madison included these provisions in the Fifth Amendment. Stating that no person shall be compelled to be a witness against himself, the amendment ensures that people accused of crimes have the right not to provide evidence that can be used against them.
The critical point is that the Constitution places the right of silence beyond the reach of government. William O. Douglas.
In 1944, Ashcraft v. Tennessee tested the Fifth Amendment prohibition of self-incrimination. When Mrs. Zelma Ida Ashcraft was found dead near her car on the side of a Tennessee highway, police held two men for questioning in her murder, a 20-year-old suspect and the victim's husband. After being interrogated under electric lights continuously for 36 hours, Ashcraft confessed that he had hired Ware to murder his wife, a confession that ultimately convicted both men. Ashcraft appealed, claiming that he was intimidated into his confession. The court agreed, overturning the conviction. Another landmark criminal rights case occurred in 1966, Miranda v. Arizona. When police arrested Ernesto Miranda for kidnapping and rape, he signed a confession without fully understanding his civil rights. Though convicted, Miranda appealed his illegally obtained confession. The Supreme Court ruled in his favor, declaring that all persons must be read their rights at the time of arrest to ensure that they know and understand their civil liberty rights. Furthermore, Miranda v. Arizona held that coercion is inherent if a person has not been informed of their rights. The right to remain silent, that anything they say can be used against them in a court of law, and the right to an attorney.
The prosecution may not use statements, whether exculpatory or inculpatory, stemming from custodial interrogation of the defendant, unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. Chief Justice Earl Warren, 1966.
The court granted Miranda a second trial in which his confession was not introduced as evidence. He was convicted, sentenced to 11 years in prison, and eventually paroled in 1972. Ironically, when Miranda himself was stabbed to death in a fight in 1976, the police arrested a suspect who chose to remain silent after being read his Miranda rights. The suspect was released and no one was ever charged with the killing. As recently as 2002, the Supreme Court again reinforced the rights of a suspect by deciding, in Dickerson v. U.S., that Congress cannot pass legislation to overrule the Miranda warning requirement. The Sixth Amendment guarantees people who are accused of crimes the right to a speedy and public trial. The problem inherent in this right lies in defining what determines speedy and public. The Supreme Court faced this problem in 1967 in the case of Klopfer v. North Carolina. Klopfer's criminal trespassing indictment was declared a mistrial when the jury failed to reach a verdict and postponed the trial at length. The court agreed that by postponing the trial indefinitely, the state violated Klopfer's right to a speedy trial. The definition of a speedy trial was further clarified by Barker v. Wingo in 1972. Barker was accused of murder, but did not go to trial until 5 years after his arrest. The case established 4 new guidelines that are now taken into consideration on every speedy trial ruling. What caused the delays? How long were the delays? Did the delays affect the outcome of the trial? And did the defendant claim the right to a speedy trial? Legislation followed in 1974 when Congress passed the Speedy Trial Act, stating that although federal trials must commence within 100 days of the defendant's arrest, the Speedy Trial Act also allows trials to be postponed when accommodating mental testing of defendants or severe illness. The question of what constitutes a public trial was examined in the Supreme Court case of In re Oliver in 1948. William D. Oliver, a minor, was accused of gambling and official corruption. At that time in Michigan, it was common for circuit judges to operate secret, one-man grand jury investigations. Oliver stood before one such judge and was immediately charged with contempt, convicted, and sentenced to 60 days in jail. Oliver appealed and won. The court declared that every citizen has a constitutional right to a public trial. The 1966 case of Shepard v. Maxwell demonstrated that trials can also be too public. When Dr. Samuel Shepard was convicted of bludgeoning his pregnant wife to death, the media publicly exploited the brutal nature of the crime, the relationship between the victim and the accused, and the social position of the accused. Shepard was quickly convicted, but appealed, arguing that the extensive media coverage prevented a fair trial. The court ruled that prejudiced media coverage interfered with Shepard's Fifth Amendment right to a fair trial and overturned the conviction.
We believe that the arrangements made by the judge with the news media caused Shepard to be deprived of that judicial serenity and calm to which he was entitled. Tom C. Clark, 1966.
The question of media involvement in a fair trial resurfaced in 1995 when the Murrah Federal Building in Oklahoma City was bombed, killing 168 people. Although the trial of Timothy McVeigh, the person accused of the bombing, was not publicly broadcast, newspapers, television, and radio broadcasters reported on every aspect, from McVeigh's arrest to his execution by lethal injection in 2001. To attempt to preserve a fair trial, proceedings were moved from Oklahoma to Colorado. However, the question was raised, was any place in America a fair venue for his trial? Another key element of what constitutes a fair trial, a jury of peers, was addressed by the Supreme Court in the 1986 case of Batson v. Kentucky. Batson, a black man accused of burglary and receipt of stolen goods, grew frustrated when the prosecutor used his peremptory challenges to remove 4 black persons from the jury pool, a move that resulted in an all-white jury. Though convicted, Batson appealed on grounds that his 6th and 14th Amendment rights were violated. The court quickly ruled in his favor, declaring that since Batson was not guaranteed a jury drawn from a cross-section of the community, the prosecutor's actions were unconstitutional. All Americans are guaranteed the right to counsel, whether or not they can afford a lawyer. While the Sixth Amendment guarantees the right to counsel in federal courts, key Supreme Court cases have extended this right to defendants in state courts. One of the first Supreme Court cases to test the right to counsel was Powell v. Alabama in 1932, now known as the Scottsboro Boys case. 9 black youths were accused of raping 2 white girls in Scottsboro, Alabama, and after nearly being lynched, were sped through the legal process without proper representation. The boys were brought to trial just 3 weeks after their arrest, and all 3 trials took only 1 day. State law required the appointment of counsel in capital cases, but the appointed attorneys made no attempt to defend the boys, appearing only to represent them at the trial. When all 9 boys were sentenced to death, the case was appealed on grounds that the trial was too speedy and the defendants were under-counseled, violating the Due Process Clause of the 14th Amendment. Ruling in the boys' favor, this was the first time the Supreme Court incorporated the Sixth Amendment right to an attorney in a capital case. In the 1942 case of Betts v. Brady, the defendant was indicted and quickly convicted of robbery after his request for counsel was denied. While in prison, Betts filed a habeas corpus petition asking the state court to determine whether his conviction was lawful, a petition that was rejected. Betts then filed a successful petition for writ of certiorari with the Supreme Court, claiming his Sixth Amendment right to a fair trial was violated when he was denied counsel. Though the court found in favor of Betts, it also stated that only under special circumstances is a defendant entitled to an attorney in a non-capital case, circumstances that include mental retardation, illiteracy, and diminished mental awareness. Gideon v. Wainwright overturned the Betts ruling 21 years later, a critical turning point regarding the right to counsel. Clarence Gideon, a 51-year-old ex-convict, was arrested for breaking into a pool hall in Panama City, Florida. Unable to afford a lawyer, he requested counsel from the state and was denied. Representing himself without counsel at the trial, Gideon was ultimately convicted and sentenced to 5 years in a state prison. After his habeas corpus petition was rejected by the Florida court, Gideon followed up with a petition for writ of certiorari with the Supreme Court. The Supreme Court then did what the Florida court would not do: provide him with a lawyer. During the appeal, Gideon's lawyer, Abe Fortas, who later became a Supreme Court justice, stated that all defendants in all cases should be allowed a lawyer in court. Lawyers were not luxuries during a trial, he felt. They were necessities. The court concurred, extending the Sixth Amendment right to counsel to anyone accused of a felony in a state court.
If an obscure Florida convict named Clarence Earl Gideon had not sat down in his prison cell to write a letter to the Supreme Court, the vast machinery of American law would have gone on functioning undisturbed. But Gideon did write that letter, and the court did look into his case, and the whole course of American legal history has been changed. Attorney General Robert F. Kennedy.
The following year, in 1964, the decision in Escobedo v. Illinois upheld the Gideon ruling, even extending it to include counsel for those accused of felonies during questioning. Chicago police arrested 22-year-old Danny Escobedo on suspicion of murder, and during several hours of question, repeatedly denied Escobedo's request to speak to his lawyer. They even denied Escobedo's lawyer, who was in the police station at the time, access to his client. After Escobedo was convicted of murder, his lawyer appealed to the Illinois Supreme Court. When they upheld the conviction, he appealed directly to the Supreme Court ruling that Escobedo's Sixth and 14th Amendment rights were violated when he was repeatedly denied counsel and that the confession was obtained illegally. This case became the precursor to Miranda v. Arizona in 1966, since it dealt with Escobedo's self-incrimination and the right to remain silent. Throughout American history, capital punishment, the death penalty, has been a controversial issue. Some consider it a necessary deterrent to crime. Others see it as morally reprehensible. Despite ongoing debate, capital punishment is currently enforceable by federal and state law, with each state having the authority to define its own rules surrounding capital crimes. Opponents consider the death penalty cruel and unusual punishment, and therefore prohibited by the Eighth Amendment.
Capital punishment's fatal flaw is that it treats people as objects to be toyed with and discarded. Justice William J. Brennan, Jr.
However, because the Eighth Amendment does not define what constitutes cruel and unusual punishment, the Supreme Court has been reluctant to rule on the constitutionality of capital punishment. In 1972, the Supreme Court began to form its position in the case of Furman v. Georgia. Furman was breaking into a house when he was startled by the resident's return. While trying to escape, Furman tripped and his gun fired accidentally, killing one of the residents. Furman was subsequently convicted of murder and sentenced to death. In his appeal, Furman argued that the death penalty is cruel and unusual punishment in violation of the Eighth and 14th Amendments. The resulting Supreme Court decision produced an extremely long opinion. All 9 justices wrote a separate opinion on the subject of cruel and unusual punishment. In the resulting decision, the Supreme Court struck down all state laws allowing the death penalty. Not because the death penalty was considered cruel and unusual punishment, but because judges and juries had too much discretion in deciding whether to impose it. Following the decision, Congress and 38 states rewrote and passed new capital punishment laws. Some states made the criteria for execution more concrete, calling for mandatory death penalty for crimes such as first-degree murder. Other states adopted a 2-trial system, 1 trial for determining innocence or guilt, and 1 trial for sentencing. One state that opted to impose capital punishment for certain crimes was North Carolina, which made the death penalty mandatory for all convicted first-degree murderers. In the 1976 case of Woodson v. North Carolina, a state court did just that, convicting James Woodson of first-degree murder and automatically sentencing him to death. When Woodson appealed, the Supreme Court determined that removing sentencing discretion is cruel and unusual, and that a mandatory death penalty rule is unconstitutional. Though it ruled against mandatory death sentences, the Supreme Court has upheld the death penalty in cases where sentencing occurs separately from determining guilt. One such case was Gregg v. Georgia in 1976. Troy Gregg, sentenced to death for armed robbery and double murder, appealed on the grounds that execution is cruel and unusual punishment. The resulting decision upheld capital punishment, becoming a model for other state courts to follow. In its ruling, the Supreme Court stated that the careful and judicious use of the death penalty can be applied if the crime is outrageously vile, horrible, and inhuman.
We are concerned here only with the imposition of capital punishment for the crime of murder, and when a life has been taken deliberately by the offender, we cannot say that the punishment is invariably disproportionate to the crime. It is an extreme sanction suitable to the most extreme of crimes. Justice Potter Stewart, 1976.